Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Elloian. Our guest today is David Daley, author of the riveting new book, Antidemocratic, Inside the Far Right's 50-Year Plot to Control American Elections. He is a best-selling author, investigative reporter, and senior fellow at Fair Vote. David has written on both redistricting and gerrymandering and is one of the nation's leading experts on partisan gerrymandering. His work has appeared in the New Yorker, the Atlantic, the Washington Post, the Boston Globe, New York Magazine, and many other publications. He is the former editor-in-chief of Salon Magazine and visiting fellow at a number of universities. Let's welcome David Daley. Welcome, David.
Thanks for having me, Mary Kay.
Now, I read your book. It's riveting. It is absolutely riveting. And let's start. How did we get here?
It's a great question. I think that you can start in a lot of different places, but in this book, I try to start with the Warren Court, and to me, the backlash to the Warren Court and the way that it tried to breathe life and really animate the Reconstruction amendments drew a backlash from the conservative right that had grown used to the previous 100 years, where those amendments that tried to give birth to multiracial democracy in the years after the Civil War had really been ignored. In some cases, they had been ingeniously defied. And I think that there are some tellings of this story in which the right likes to suggest, well, the Warren Court was legislating from the bench and they went too far, and it was time for the actual words of the Constitution to be listened to once again. And I would suggest that that is as much of a myth as it is that John Roberts is simply calling balls and strikes. So Congress, after the Civil War, passes the Reconstruction Amendments, the 13th, 14th, and 15th Amendments that end slavery, that extend Blacks the right to vote, that ensure equal protection under the law. And immediately what you begin to see from the US Supreme Court is a whittling away of these rights, an unwillingness to allow the federal government to enforce them in the Cruikshank cases and the Civil Rights Act cases. And that, in many ways, is what helps lead to the century of Jim Crow that the Voting Rights Act of 1965 tries to end, and which the Warren Court has to stand up and insist that Southern states follow it, because we think sometimes of the Voting Rights Act as being a halcyon era of agreement that it was time to do this, when in reality, South Carolina sues the federal government about a month after the passage of the Voting Rights Act and says, no, this has gone too far. You're infringing on states' rights. So the Supreme Court, the Warren Court, needed a muscular defense of multiracial democracy in the 1960s. But by doing so, it opened up the sort of backlash from the conservative right and the conservative legal movement. And what you begin to see is the growth of the idea of legal originalism. You have Lewis Powell and his memo telling conservatives that they need to fight for America in the courts.
Now let's talk about Lewis Powell for a moment.
Absolutely.
Who he is, or who he was, how he got into the Supreme Court, and let's carve that path forward.
Absolutely. I mean, Lewis Powell had a fascinating life. Powell was an attorney in a corporate lawyer in Richmond, Virginia. He worked for many of the tobacco companies, for Philip Morris and the like. He was defending tobacco and cigarettes as one might when you were a courtly corporate lawyer in the South in the 1950s and 1960s. He's the chairman of the school board in Virginia in the mid 1950s when the Brown versus Board of Education decision comes down. And Lewis Powell simply doesn't understand this decision. He thinks Brown was wrongly decided. And Powell is given credit by his biographers, by those who would like to cast him as a Southern gentleman for not taking the path of maximal defiance. And it's true that Lewis Powell was not Bull Connor standing in the doorway with dogs and a fire hose stopping Black students in Richmond from attending school. But what Lewis Powell did instead was simply ignore the decision. And by the time he left office in 1960, you could count the number of Black students in white schools in Richmond on one hand. And so Lewis Powell throughout the 1960s is writing screeds, really angry manifestos about the civil rights movement, about the anti-war movement, about what's happening on college campuses. And as the 60s turn into the early 1970s, he's up in arms about the environmental movement and the consumer movement that Ralph Nader is pioneering. And he writes a memo for the Chamber of Commerce that gets to them in 1971. And what Powell says is that we have to fight for the free enterprise system. We have to fight for our beliefs as conservatives in America. And the way to do this, the greatest opportunity is in the courts. Powell, amazingly enough, just a handful of months after writing this memo, is named to the US Supreme Court by Richard Nixon. And Powell uses his seat on the Supreme Court to deliver decisions on campaign finance reform in First National Bank versus Bellotti, for example, which is one of the key cases that leads to Citizens United 30 years later. It's cited probably 24 times by Anthony Kennedy in that decision.
And that's the dark money case.
That's the dark money case. But
elections.
Powell's memo, in the meantime, inspires the Koch brothers. It inspires Joseph Coors. It inspires the conservative funders, the scions of the right, like Scaife and Mellon and the Olin
Mellon
Foundation.
Chafee, I should say.
Yes. And so all of these foundations step up their giving and their donations. They fund the American Enterprise Institute and the Heritage Foundation and a series of public interest conservative law firms around the country. And they begin to create the right-wing conservative infrastructure, much of which that exists to this day.
Now, wasn't it the fact that they did not like what the Warren Court did? Warren Court in the 60s was expanding rights. They were reading rights from the Constitution. In other words, they were saying, there's personal rights here. They were expanding rights. And Powell and his cronies did not like the idea of expansion. That's the way I read this.
They were expanding rights for people who Lewis Powell did not necessarily want to see rights expanded for. Blacks, minorities, anybody who did not look like him. Lewis Powell's biographer notes that he never met a Black as an equal, which is a pretty staggering thing to say about somebody who would rise to the US Supreme Court. And to me, if you look at the cases that the Warren Court decided, and I think that the key cases there are really the apportionment cases of the apportionment revolution that really cemented the idea of one person, one vote. And we think now about yes, we think now about redistricting as something that happened every 10 years. And yet from 1900 to 1960, the number of states that redistricted every 10 years, it was probably 50-50. And we think now that, oh, of course, districts have to be of equal population. That was not the case at all prior to these cases in the 1960s. State legislatures would district themselves, oftentimes based on counties. So Alabama, Tennessee, Nevada, state after state would say, well, it's not equal population. It's that every county is going to have one a senator. And you would have these wild population disparities from district to district. And of course, if most Black citizens lived in the cities, there was also a racial implication here because these districting processes favored white, rural, conservative interests. And it was quite intentional. And so what the Warren Court was doing was really saying, no, this is not okay. The idea that the Warren Court was some, renegade, wild-eyed expander of rights, I think is only a possible read given just how retrograde and defiant the Supreme Court had been in the previous 100 years and how unwilling that court had been to truly enforce the word and the spirit of the Reconstruction Amendments to the Constitution.
Now, Lyndon Baines Johnson, he signed the Voting Rights Act in 1965. And I think that is what set all this in motion. The
Yes.
fact that Blacks could vote, and there was no limitations on it. I think that seems to be the undertone here. And I noticed in another interview I did with another attorney who lived through this, he talked to me about his own interactions with William Rehnquist. And I believe he also testified in Congress. So let's talk about a little bit about that portion.
Sure. I mean, I think you're absolutely right. I think that the signing of the Voting Rights Act set much of this in motion. And it did so because Lyndon Johnson insisted that the Voting Rights Act have teeth and that it work. The previous acts, the Civil Rights Act of 57, of 59, they didn't completely work because the enforcement mechanism wasn't strong enough. It relied on federal judges in the districts where these claims were being brought to rule on them. And sometimes these were segregationist judges, or they were friends with the sheriffs, or the politicians down there could simply find ways to get around them faster than DOJ could win the cases. It was like playing whack-a-mole. And so what LBJ does with the Voting Rights Act is say there's going to be preclearance. Section 5 of the Voting Rights Act mandated that the states and localities that had the worst history of racial discrimination in voting, they were going to have to get any changes they wanted to make to the law pre-approved. Not because the state wanted, not because the federal government wanted to be their nanny or their parent, but because those states had proven for 100 years that they could not be trusted to do this on their own, because they had ingeniously defied the Constitution for decade after decade, resulting in bloodshed and lynchings and huge inequities. So
there was also
that gets in the way.
Requirements to vote too, put on these folks as well.
So I think that really is what is so important to think about as we're thinking about the backlash. The backlash comes because suddenly these states couldn't get away with what they had been allowed to get away with for the previous 100 years. And they were being told by the federal government that time was up. They had to really change. And you had men like William Rehnquist, who was a lawyer in Arizona, during this period. And Rehnquist was spotted, at polling places in Arizona, personally trying to prevent Black and Latino registered voters in Arizona from casting ballots. And when you think of William Rehnquist doing that and then being appointed to the US Supreme Court on the same day as Lewis Powell and rising to become the Chief Justice of the US Supreme Court, not in the 1800s, not in the 1900s, not in the early 1900s, but he was Chief Justice of the United States Supreme Court until 2005. Somebody who personally tried to block minority citizens from the polls, was the Chief Justice of the United States until the early part of this century. It's hard to wrap your head around that. And what I would add to that, just briefly, is that the current Chief Justice of the United States was his clerk. So you can draw this line, Shelby County case likes to say things have changed in the South. And so pre-clearance was no longer needed. But you know where things haven't changed? In the Chief Justice's chambers of the US Supreme Court, where there's this straight line between Roberts and Rehnquist, and Roberts deciding that pre-clearance is no longer needed, and Rehnquist personally threatening minority voters in Arizona. Nothing has changed.
It's shocking. It is shocking. I know in my interview with James Brosnahan, who's an attorney who actually personally testified in Congress many, many years ago. He was my guest, and he talked in explicit detail about the William Rehnquist situation and him actually walking up to people with constitutions and saying, "Read this," because he suspected they couldn't read very well in English. So
very intimidating, very, very intimidating, and very illegal.
Yes. So I see some of those same actions playing out a little differently today, a little bit more under the radar, but still
a little more technical, a little more race neutral, as they say, but
yeah, a little more nuanced today.
Right.
In fact, there was a recent case that I just spoke about, the South Carolina voting rights case, South Carolina v. NAACP. And in that case, they held that actually Chief Justice Roberts authored that opinion as well, basically saying, as long as it's about partisanship versus race, and as long as you can justify partisanship, you're good to go. Even if there's a little bit of racial discrimination going on there, it's as long as the majority of it is for partisan intent, you're all set. And we see how the erosion of this pre-clearance is actually ruining the racial makeup, the voting rights of the people who are either Black or Hispanic or minorities. So John Roberts has really been invested in this for about, what do you say, 50 years? How long has this been going on?
This is John Roberts' life's work. Yeah. Preventing the full-throated authorization and success of the Voting Rights Act has been John Roberts' life work. This is his legacy. You can trace it back to John Roberts' first days as a young man working in the Reagan Department of Justice, when he is the key point person at DOJ. He's in his mid to late 20s, and he is tasked with preventing the congressional version of the reauthorization of the Voting Rights Act. And when you go back and look at his memos and his talking points and the draft op-eds he was working on at the time, what he was saying behind the scenes, what John Roberts was saying is, we don't want to make it too easy for people to prove a violation of the Voting Rights Act. And indeed, he has gone on to ensure that it would not be too easy from the bench. Roberts, in a series of cases that has really remade American democracy, as Chief Justice, has unleashed unlimited dark money into our political system,
Citizens
has
United.
taken in Citizens United in Shelby County. He puts an end to preclearance, which is the crucial enforcement mechanism of the most important and successful civil rights law in American history. In
Which
that
means
decision,
that they need to go to the federal government to make sure
right,
that they drew the district lines okay, and
that's
they're
right.
not really doing it disproportionately. But again, that recent case of
Yeah,
Alexander,
versus
South
South
Carolina
Carolina
versus
NAACP, yeah,
NAACP did away with all that.
which is
Pretty
part of a continuum, right? So you get Citizens United in 2010, you get the Shelby County case in 2013. Roberts in Shelby County says, well, we don't really need to have Section 5 because we still have Section 2, which prevents this kind of behavior nationwide. And then you get a
Section 5
series
preclearance,
of
yes.
cases aimed at Section 2, whether it's the South Carolina case, whether it's Brnovich versus DNC from 2021, whether it's Abbott v. Texas, right? So Roberts, and then of course I don't want to miss the decision in the partisan gerrymandering case, Common Cause versus Rucho from 2017, which is so important because once you've closed the courthouses to partisan gerrymandering claims and said that those are non-justiciable, you make it a whole lot easier for people to say, oh, this is a partisan gerrymander, when really what you're doing is a racial gerrymander.
Right.
So Roberts has set all of these cases up in a really strategic long-term fashion. A lot of his fellow justices would like to move quicker. Perhaps one might, from my point of view, look at them as constitutional arsonists. If they're constitutional arsonists, Roberts is not going to light the house on fire. Roberts is going to take the house apart board by board slowly. Roberts is an incremental constitutional bulldozer.
Mhm. So, all right. So I understand. So the other ones want to burn it down, and he's like kind of the slow burn guy.
Yeah,
Um,
there's that Johnny Cash song, One Piece at a Time, right? In which he talks about, someone working at a car factory who steals a car just by taking one piece of it home every day. And that really is what Roberts has been working on ever since 1981. If you just take one little piece out of the Jenga game, it doesn't all collapse at once. It collapses so slowly that people don't even know it's gone.
exactly. So I want to back up just a little bit to the Federalist Society.
Mm,
I think they have played a remarkable, um, had an effect here.
yeah,
If you, can you talk a little bit about the Federalist Society, who they are and how they
absolutely.
evolved?
The Federalist Society begins in the early 1980s. It is launched by a handful of conservative law students who feel as if conservatives are underrepresented in the academy. They take their um, real first break from a man named Michael Horowitz, who wrote a memo that is not as well known as the Powell memo, but tried to update what Lewis Powell wrote about almost a decade earlier. And what Horowitz suggested was that the infrastructure conservatives really needed was in the law schools, that they needed a pipeline of smart young people who could be trained and brought into the movement, because he thought that the current movement was appallingly mediocre, in his words, in terms of inspired brain power. And so Horowitz introduces these young law students to all of the institutional donors on the right that we talked about earlier, and they help fund the Federalist Society. And
Which
this is
began at Yale.
probably this in American nonprofit history, because the Federalist Society has grown into probably the most important legal organization in America, perhaps even eclipsed the American Bar Association, right? In terms of its influence and its power.
And many
What
judges have come through the ranks of the Federalist Society.
what the Federalist Society has created really is a minting apparatus. They
Well,
like to think of themselves as just a humble debate club on college campuses. But really, the debate club is the front for what goes on behind the scenes. The debate club is the social club in front that disguises the gambling uh, numbers racket that's being run out of the back, right?
Mhm.
And that's really where the Federalist Society influence comes from, um, because um, what conservatives built here is an apparatus by which they got to know and understand and approve of everybody as they entered the conservative legal movement. So Horowitz, Edwin Meese, the folks who worked in the Reagan DOJ, they began to hire all of these young people straight into the Reagan White House. And it became known really quick that this was the club to join if you wanted access to power, if you wanted to be part of the conservative legal movement. The Federalist Society had to know who you were. And so in the first Bush administration, you have young Federalist Society founders who were involved in the vetting of judges, but it still wasn't enough, right? Because David Souters and the like were still slipping through. Conservatives were appointing justices who would still continue to kind of let them down once they got on the court, and so the
Well, that doesn't happen
vetting,
anymore.
it doesn't, because the vetting a piece of this, which is really what Leonard Leo took over, at this idea that conservatives were going to get to know absolutely everybody coming through this process. And if they didn't know you in the Federalist Society, you were not going to make it on the bench, right? So when George W. Bush tries to put Harriet Miers on the court in 2005, the Federalist Society folks just stand up and say, we don't know who you are. We don't trust you. And they push Miers out of the process, and Sam Alito comes in instead. And
Oh,
Leonard Leo tells the New Yorker, I've been a fan of Sam Alito's for a long time. And so the Federalist Society is a piece of this big operation on the right that Leo runs now with about a $1.6 billion dark money budget, all of which is designed to generate conservative legal victories. The Federalist Society provides the judges and sort of the intellectual firepower that fills the briefs, the amicus briefs, and then the other arms of the Leo octopus help start the litigation, help fund the litigation, the lawyers, they find the plaintiffs, and they get these cases before the judges that they have handpicked to hear them. If this sounds like a hermetically sealed circle, it's because it is.
mhm. So it's strategically they bring these cases so they can erode the rights little by little by little by little, and then they have the people on the bench that will rubber stamp it basically.
Exactly right.
So it's outcome determinative.
Yes. Leonard Leo, the Federalist Society, and the big conservative corporations and nonprofits and foundations are all invested in every piece of this. They've built an iron triangle of 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 litigants, um, of law firms, and of judges in such a way that you can trace all of this, right? You can take a look at the Shelby County case, and it's brought by a man named Edward Bloom, who's become famous, of course, for bringing the affirmative action cases as well, a lot of the key cases on race. But if you look at who has funded Bloom's work, it's oftentimes the very same organizations that are funding the Federalist Society. There's a big conservative organization called Donors Trust, which is known as the ATM of the right. And Donors Trust and these big conservative nonprofits fund Bloom. They pay who goes out and finds the cases, who brings them Shelby County and the plaintiffs in Calera, and then they fund the white shoe conservative law firms that spend hundreds of thousands of dollars, if not millions of dollars, on the cases. They fund the amicus briefs that are filed in support of these cases. They funded the research and the legal theorizing that goes into these amicus briefs through the law schools. And then these cases go before judges that the Federalist Society has helped vet and oftentimes hand select and give Donald Trump a list of acceptable conservative judges that Trump actually selects from. So is it outcome determinative? Absolutely.
It seems like a closed system of justice. You bring the cases, you have the judges, you stack the deck, you win, basically.
There you go.
And the American people aren't aware of this. I think a lot of them aren't. Maybe some are starting to be aware, but they really stand for big business, for the billionaires that fund them, not the average citizen. They stand for corporations, and we see that in the Project 2025 manifesto that I've embarked upon reading. So it's the erosion of those personal rights even more.
Yes, I think that's exactly right. And if there's a theme to this book, it is that conservatives understand that they cannot win these policy victories through the political process, because these are unpopular decisions that favor plutocrats and billionaires, and what has become and those who would keep this a non-multiracial democracy. So they have relied on the courts, exactly as Lewis Powell suggested, and as the Federalist Society and Leo and others have implemented and perfected, in order to achieve policy victories that they could never win otherwise. And so if you look at it that way, John Roberts is less the Chief Justice of the United States than John Roberts is the most successful Republican politician of the last 25 years, because he has handed the right victories on campaign finance, on voting rights, on abortion, on guns, on the regulatory state, on the unitary executive theory, on the major questions doctrine. He has handed the right victories that they could never, ever win through the political process. And because they control the US Supreme Court, they do not have to win through the political process. We have a Federalist Society court that meets in private with lifetime tenure, with no accountability, with no ethics standard, that has effectively wielded veto power over the elected branches of government, all while expanding and making more muscular its own policy and power. And I think that we ought to consider that not only frightening, but anathema to the idea of representative democracy.
Exactly. Well, on that whole issue of represented democracy, and I wanted to talk a little bit about, just briefly, about originalism, which is what they tend to do. The justices tend to, it's their go-to to justify some of their atrocious rulings. Originalism, I'm quoting from your book, didn't lead to neutral answers. It led to different answers, swaddled in theory and garb of the founding fathers. I
Hmm.
thought that pretty much encapsulated it to a T, because they always say, oh, originalism, there was no right to abortion, there was no right, you know, it's swaddled in in the garb of the founding fathers, while halting and showing the expansion of rights, including voting rights, the founders didn't include. So that's kind of, I think that was that Bork had written something of that nature? Robert Bork, was it?
Yeah.
Who was
You can
also
trace
instrumental in the Horowitz memo and of
That's
this
right.
originalism theory.
You can certainly trace originalism. I mean, back. I think, there's a tremendous scholar, Calvin Trebeek, who has traced originalism, um, the popular birth of originalism to the days after the Brown versus Board of Education decision. And that is really when you begin to see folks on the right in National Review and other places, the Goldwater, campaign, and those who were building that up ahead of 64, talking about original intent and the actual words of the Constitution. It was a way of slowing the actual pace of evolution towards multiracial democracy. Because, of course, if you were to look at the original words of the Constitution, we all, it was written by white men, and it only included white men.
Mhm.
And so as the Constitution began to be interpreted, with Brown v. Board and the cases that would follow in the Warren Court, you begin to see this, well, how are we going to get this back? And the opponents of this change, they don't want to come out and say, we're trying to defeat multiracial democracy.
They don't want to say they're racist.
They don't want to say they're racist. They they would rather say we're originalists.
Right.
We're not standing in the way of progress. We're not Bull Connor. We have this, we just have an academic, intellectual way of looking at the Constitution, which happens to be looking only at the Constitution of, 1789, and what those exact words by those white men were. So they get to the result they want
Mhm.
without having to have all of the racist stuff in between. It's a really neat way of
Mhm.
whitewashing, so to speak.
Literally.
Um, and getting the policy outcomes that they want, while proclaiming that they're up to something completely different than what they actually are doing.
Right. Because if they were truly originalism and they come out with the results they do
Well,
in today's
it's
society.
because they are only using originalism as a fig leaf, and they use it when it's convenient for
Exactly.
them, and when it's not convenient for them, they pick up
They
something else,
discard it. Yes, yes.
or they say it means something different. So it is originalism is a Trojan horse, and
Mhm.
it is designed to provide some sort of justification for the outcomes that conservatives want the court to reach.
Mhm. To justify the unjustifiable, basically.
That's better said than me. Thank you. Yes.
Any last words or you'd like to add to our our discussion today?
I think it's really important to um, understand that the Chief Justice took office in 2005 saying he was going to call balls and strikes. He was going to be an umpire. And, John Roberts is an umpire. He's an umpire like Leslie Nielsen was in The Naked Gun, if you remember that baseball movie, right? Where he's calling the balls and strikes the second it leaves the pitcher's hand. The strike zone is simply different based on which team he wants to have win. He has really ripped up the rule book and inserted his own. And when you look at these important cases, when you look at cases like Shelby County, they're not justifiable in law. I mean, Roberts is essentially making the law up as he goes along. The Supreme Court has a credibility problem right now, and it has a credibility problem of its own making. Uh, and the kinds of reforms that I think we need to see, whether we're talking about term limits, whether we're talking about ethics standards, excuse me, whether we're talking about, expanding the court and finding ways to sort of rein in the power of a renegade court. Americans support this. I mean, if you look at there's a Fox News poll that shows 78% of Americans think that term limits for the Supreme Court is a good idea. This is popular, and it's popular for a really good reason, because Abraham Lincoln, back in his first inaugural, says that if the Supreme Court is to have the power on all issues of public policy to fix outcomes, and I'm paraphrasing that first half, but the second half is word for word. He says that the people will have ceased to be their own rulers. And I think that what we all recognize now is that Lincoln's words were prophetic, and that we are in a moment in which the Supreme Court has taken on that power. And in a representative democracy, we shouldn't be comfortable with any 9 people having that kind of power over all of us, or indeed, we have ceased to be our own rulers.
Exactly. And especially where the rules are antithetical to the majority of the American population. They are not representative of the will of the majority of Americans.
That's right.
Well, it's been a pleasure having you. And I wish you success with your book.
Thank you so much.
Riveting.
I really appreciate the chance to talk about it.
Thank you for coming on. I want to thank our guest, David Daley, for sharing his research and opinions on partisan gerrymandering and the perils facing our democracy. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guests, visit us online at thelegaledition.com. And as always, this information is for educational purposes only. It is not to be construed as legal or personal advice. So please consult a qualified practitioner as to your own legal or personal needs. And don't forget, subscribe online. Find us on Facebook, YouTube, Instagram, and Twitter, now X. And subscribe to our publication on Substack.